TTRLA, man, we are back with another clip. You know what I mean? Amen. Say, man, what are you doing right now? Can you go ahead and like, subscribe, and share to my channel? Like and subscribe and share to my channel. I know you randomly came up on my page, but just go ahead and like and subscribe. Take a listen. I'm about to drop my insight on day 12 of the YNW Melly murder trial case. So this is a very interesting day. The jury is not in the court. It's just the prosecution and the defense. Now, the defense has brought up an issue, is going to be bringing up an issue to the judge about the state's witness that they have possibly going on stand to testify against YNW Melly. Now, the defense is making an argument that basically the prosecution did not vet this person properly, because how is he going to be a state's witness and he has charges? He is facing criminal charges against the police and robbery and something like that. So who's to say that this dude is not getting on the stand to testify in order to relieve pressure off what he got going on? That's the defense's stance. And then also the defense is saying basically in the Florida state law, in order for them to do a deposition, this is kind of like against everything, because, you know, how is the prosecution and the defense going to do a deposition and the state's defense attorney is not really advising this dude of his rights, you know what I'm saying, to plead the fifth or have an attorney present? And the prosecution is like, shit, y'all go ahead and depose him. You know, if he want to plead the fifth, he can. If he don't, damn, this is like, damn. So that's what's going on right now. I think the defense, they have a slam dunk case right now. They slam dunking shit. You feel me? Tim Duncan, the white dude, he was going up there, boy, he was making his case like a bitch. You feel me? So this case is getting interesting. I'ma stop rapping and we gonna get moving to it. Shout out to Gas, not Gas.
I think we had another problem that needed assistance from the court. We started the deposition of Trevon Glass this morning.
Who is Mr. Glass?
Mr. Glass is a named witness at the state of It's the witness that they gave us a new address just about 2 weeks ago, or a week and a half ago. As we were meeting this morning, when I say meeting, the defense team was meeting, we ran Mr. Trevon Glass criminal record and found that he has a pending charge up in Indian River, and that he has a lawyer, according to the docket sheet. We attempted to reach that lawyer by the name of, I think it's Justin Barenborg, B-A-R-E-N-B-O-R-G, from the Public Defender's Office out there. He was not in, but his secretary, which I believe her name was, I think it was Julie, but I'm not positive. I really wasn't paying attention to her name. But wanted to speak to him because his client was being deposed, and she indicated that no one gave her notice about the deposition and what have you. When we started the deposition, I asked him if he had...
Now, I want y'all to peep the prosecution's arms. Her arms are folded to the side, which means, you know, body language in a lot of cases matter, right? So when somebody folds their arm, it means a couple things. It means that they're trying to listen to understand because they don't understand. They're folding their arms because they're upset. They fold their arms because they feel like maybe they fucked up. So I feel like she on the fucked up side of the folding of the arms, because she knows she messed up and she moving real sloppy. I mean, she had some slam dunk case. Do I feel like YNW Melly murdered his two best friends? No. I truly honestly don't believe that YNW Melly murdered his two friends. Do I feel like he knows what's happening and what's going on? Hell motherfucker yeah. I know he knows why something took place, who did it, but I think I don't know about this. Why he not? I don't know about this part in this whole story about regarding why he it was even considered to kill. I don't even know. Like that's the unreasonable doubt part of this whole situation, because like it's just not making sense. Now if he did kill him, like, cuz like you vicious as shit, like why you doing this? Like why it don't even make sense. So I feel like the defense is making a good case in this situation. All right, I'm gonna stop talking and get back into it.
To raise any Fifth Amendment claims as necessary. There is no discoverable information that could come from the pending charge other than whether or not any promises or anything have been made to the defendant by the state in exchange for his testimony, of which there have been none. So that would be the only area of inquiry that would be reasonable under the facts and circumstances of this case.
Well, if they told us I contacted his lawyer, we wouldn't be here, we would be in a deposition. I don't know what the secret is, and wasting time, quite candidly. But with all due respect, we do plan on asking questions because we believe one of the crimes deals with moral turpitude. And I don't know who is going to invoke or tell him whether or not he should or should not answer. Certainly we can't, and I believe the state cannot. So if the attorney is available during the deposition, fine. But the first question I'm going to ask him is, do you want to waive your right to have an attorney to decide if you have a valid Fifth Amendment right on any question we ask?
Chair, with regards to, I don't understand how here crime of moral turpitude, that's a well-defined area of the law. The crime in question is resisting an officer without violence.
That's not true. It's also interfering with the execution of a search warrant. The other count.
Sir, executing a search warrant, which is a misdemeanor charge.
Hey, the way the defense throwing up his hand, he fed up. My man got the on his Johnny Cochran. If the shoe don't fit, we must acquit, Your Honor.
And under the discovery rules, we have a right to inquire about anything that may lead to additional impeachment evidence. So when they say it's only resisting arrest, that's what they told us yesterday, but that we have found out that is absolutely incorrect.
And Judge, that representation is also incorrect. I filed a supplement yesterday. I provided the defense with the information for Mr. Glass's case, which includes both counts, so they were advised.
So when was this information filed?
Yesterday, Judge, which is when the witness showed up.
Sorry, I'm not being clear with the charging document. When was that filed?
And again, just to remind the court, this is a witness that was previously uncooperative, failed to comply. We did a random search about 2 weeks ago, found that he had been arrested. The information was filed on June 19th of 2023. So fairly recent. Yes, very fairly recent. I believe all he's had is an arraignment so far with the public defender. Again, this witness is also from very weak, so he's not from Broward County. He traveled yesterday, came, he was supposed to take his deposition yesterday.
I like how this police officer's casually walking by, sipping his damn tea and shit. If you don't sit your Stone Cold Steve Austin, shape up body, built body, back ass boy, sit down somewhere. Just sit down. It's all moved. Just stand and sit down.
Invoke the right without his attorney present. He's chosen to go forward at any time of deposition where he chooses that he may want to speak with his attorney. He can invoke that right, and that right belongs to him and him alone. So I don't think we need the court's interference at this moment. We can proceed with the deposition.
Thank you. Anything else you want to share with me?
No, sir.
What's the relief that you're seeking?
I'm seeking to postpone this deposition so that he can have his attorney present. He's a young man, and for him to decide what questions may or may not incriminate him, with all due respect, it's foolish to believe he knows that
Hey, when the defense was talking and he said foolish, I thought he was saying full of shit. I was like, ooh, he's slick with the words. That was up, no disrespect, but this full of shit. But he said foolish as shit. But the judge is really this judge is amazing. I just want to say the judge is amazing. He's hearing all people's side. He's not being biased. He's definitely just going based on law, and he denied prosecutions wanting to have the vehicle in the courtroom or some dumbass shit like that, so that the jury can see the vehicle and put the case. Like, no, we don't need that shit. And I'm glad the judge denied that bullshit, because like, what the fuck? That don't even make sense. They got millions of pictures. They don't need a car. It's the biohazard blood. Like, what is the prosecution doing? They trying to slam dunk the joint. It's already, you know, looking like Melly about to get death anyway, you know, just based on the evidence. But the defense is doing their best to create reasonable doubt, and I think they're doing a hell of a job.
And I think ethically, I have to bring that to the court's attention. And I think it's negligent on part of the state not to notify his lawyer until we're starting the depot. And it's absolutely foolish for the state to come in here and say he can invoke his right anytime he feels like it. That's why you have a lawyer.
And Judge, just for the record, this is a defense deposition where they're deposing a witness. And again, the state's position is that the witness himself needs to invoke that. The state cannot give him legal advice, just like the defense indicated they cannot. So it would be for the witness to invoke that regarding any questioning. And the defendant is clearly indigent. He has a public defender. His jurisdiction is solely in Broward County Beach. They want an in-person deposition. Surely that public defender is not going to travel here. But the remedy, of course, we'll ask him and see if he's available to appear on Zoom. And that's a remedy. We would ask that it not be suspended beyond today, because we intend to call him on Monday, as the court's aware. The state intends to rest next week, so we don't want to prolong or delay this deposition more than it's already been delayed.
Thank you. Anything else?
No, sir.
All right, I'm just giving you a little bit of time. I need to take a look at it, and I'll let you know if sharing any cases would be correct.
No, haven't had time to do research or anything that's been provided from defense on this issue.
My thought process is that defendants individually raise the right to a lawyer all the time, and they do it when they're the suspect of the ongoing criminal investigation, as well as when they make that decision and they're advised that their Miranda rights, and they waive them without lawyers being present, and they do it all the time. So I don't know if how going into something. What's the date of the charging document?
Ready?
Not you told me that June 2023, but the alleged incident.
Oh. Judge, it's on or around the end of May 30th.
2023.
Correct.
Some several years after the incident in question, right? We're
Yes.
talking October 26th of 2018.
Yes.
Almost 5 years. All right. So, in any event, since nobody provided me with any case law on this, I'll take a look. I don't know what rule you're saying, with what rules that the state is violating. You said they're in violation of the rules. Travis, what rule is?
I think the Florida bar rules provide that when you know that someone is being represented, this came as a surprise to me.
What the rule number is?
I'm sure in the heck don't.
And so it's clear there's been no filing of any notice of appearance on behalf of the witness in this case to give notice to the state on that, which plenty of other witnesses have done.
All right, just give me a few minutes. I'll take a look at it. What about the other motion? There was a deposition supposed to be taken from your expert. Was that done?
They started yesterday, and the state is providing him some additional information, and I think they're going to set up another Zoom hearing on
Hearing or deposition?
Pardon?
Zoom hearing or deposition?
Deposition.
Yes, Your Honor, we have bifurcated. The defense expert indicated that the information that was sent to him by defense counsel was corrected, so he wasn't able to actually review any of the information to give it this evening, and then we'll continue with his deposition tomorrow at some point.
How about there's the state's motion for a jury view. We talked about that as well. That's supposed to be set for review. Still going forward on that motion?
Yes, Your Honor. The state would rely on the written motion and Your Honor's recollection of the testimony and argument that was made in open court as to how it would benefit the jurors. It is separate and distinct from the other items. In fact, the state would submit that the state could offer the entire car into evidence because it has been preserved. It has been in the same condition since it was initially put forth. And that would, there is no limitations in the evidence code as to the size of the piece of evidence. If it doesn't come in through the courtroom doors, Your Honor, the state would submit that there would have to make arrangements for the jurors to be able to view the item of evidence.
I did file a response, Your Honor. Were you able to read?
Yes, ma'am. I'm sorry. Anything else?
I would just add that we have yet to view the car ourselves. We're supposed to go see the car this afternoon after court. But as I set forth in my motion, I believe it's overkill. The witness testified to the specs, the measurements in the car. We actually have photographs that have been moved into evidence that have measuring sticks that clearly show you the distance in the car. Her proposition that we need to see the car so that we can see the purview, I guess she's finding out who's jurors sitting inside the car, which makes no sense because they don't have the same measurements as the decedents. Moreover, I'd like to point out, we don't even know where the decedents were truly sitting because there are no crime scene photos that actually show them being in the car at the hospital. All the pictures that we were shown are of the decedents, the car being empty. So I would even argue the proposition of what she's trying to say, this person sitting here, this person sitting here. There's no actual evidence that that's how they were sitting.
All the more reason why it's important to be able to see the car and the defects therein. Counsel makes a great argument for
And
that.
I'd also argue it's a biohazard.
And so in terms of, there's never any indication that jurors would be sitting in the car whatsoever, so that would be inappropriate.
Then you make my point. We have enough pictures that have been moved in. Which much of the theme of this case is overkill. It's redundant. They don't need to see the car to get the understanding of the size of the car. I think we got that with the measurements and the pictures.
Anything else to roll on?
Yes, Judge.
Yes, sir.
Thank you. Respect to the motion tonight. I don't think it's necessary to have a jury view. I don't think it's essential. We've got the photographs of the vehicle in question. I don't think it's going to assist the jury to any great degree in analyzing the evidence. So, respect to the motion tonight. What about the motion to compel?
That's the deposition of Mr. Glass that we were working on.
I thought you were...
Oh.